3.06 that reads, you must accept as conclusively proved any fact to which the parties have stipulated. Is that correct, Mr. Rivera?
That's correct, Your Honor.
Is that correct, Mr. Ocampo?
It is, Your Honor.
All right. Now, what I would like to do is to make sure that Mr. Capobianco is in agreement with all of this.
That would be fine with the defense, Your Honor.
Good afternoon, Mr. Capobianco. Good afternoon. Mr. Capobianco, your attorneys, on your behalf, have agreed to enter into a stipulation with the state of Hawaii that I've just read into the record. Did you hear me read that into the record?
Yes, I did.
All right. And if you stipulate to the facts set forth in the stipulation, you are relieving the state of Hawaii, the prosecution, of proving this to the jury through sworn testimony. Do you understand that? And any exhibits that they might offer. Do you understand that?
Yes, I do.
Typically at a trial, a defendant charged with an offense has the right to see, hear, and question any witness who might testify against that person, call their own witnesses regarding any matters that might be presented at trial, and to either testify or to remain silent with respect to information that might be presented at trial. Do you understand that?
Yes, I do.
With respect to the facts set forth in this trial stipulation, if the court does read this to the jury will be instructed that it must accept these facts as conclusively proved. Do you understand that? And that will mean that those trial rights that I just mentioned to you will be given up with respect to these facts. Do you understand that?
Yes.
Is this something you've, without telling me any attorney-client communications that you might have with your attorney, or your attorneys, I just want to make sure this is something that you have full opportunity to discuss with your attorney.
It is.
And the decision to enter into the stipulation, is this something that you are in agreement with?
Yes.
And you feel you've been fully informed with respect to this particular stipulation?
Yes.
Do you have any questions?
I think we should keep this on that once and all.
Have you understood everything we have discussed?
Yes.
And do you wish, or do you want the court to read the stipulation into the record as well as the instruction that I've just read?
Yes, I do.
Okay. All right. And I'm satisfied that. Well, let me just make sure. Are you doing this voluntarily? Is anybody forcing you to enter into this stipulation?
No, I'm doing this voluntarily.
Oh, all right. Thank you so much for answering my question. Thank you. All right. I'm satisfied the defendant has intelligently knowingly voluntarily with the advice of counsel agreed to enter into the stipulation with the state of Hawaii. That is done so with the understanding of the nature of consequences of such a decision. So I will accept the trial stipulation. I will read it, and I will instruct the jury. Of course, we'll be providing the jury with written instruction at the conclusion of the trial that, with regard to the stipulation of the fact. And I also know for the record, and this is something that the jury must not be exposed to, but I will note for the record that I do understand in the context of the evidence here that one of the things that occurred between 8:24 a.m., the first statement, and 11:22 a.m. on February 12, 2014 was a polygraph examination. And this stipulation creates a record where the jury can be informed accurately that there was a full advisement of Miranda rights without having to go through the sequence of that, because the polygraph examination also included a full recitation of all Miranda rights to the defendant. And obviously, under Hawaii case law, all of that is inadmissible and therefore will not be presented to the jury. So I do understand the reason and the reasoning behind the parties entering into the stipulation, and where the court says that's sound trial judgment. All right. Anything else that you want to say about this, Mr. Rivera?
Not about the trial stipulation, Your Honor. Thank you.
Mr.
Not about the stipulation, Your Honor.
Okay, and Mr. Capobianco, anything else about this?
Sir.
All right, thank you.
I
Is there something else?
Delete that, I wanted to keep it in. They already testified to it earlier.
Nothing relative to this issue, Your Honor. We're discussing the transcript of the second.
Oh, okay. Do you folks need a little, I know you're working on some of the
Truthfully.
logistics.
Yeah, okay, so my co-counsel's back and he's been in the lead on this. They may need a couple minutes.
All right. I'll give you that time.
Thank you, Your Honor. That's my copy.
No more.
And you know, I know you folks are working on just making sure that everything is in order with respect to the transcript. Take some time to make sure that's done correctly. I don't know how long that'll take. I'll sit here while you take care of that. I do want to make sure that it's done correctly.
This one copy. If this is anything I'm
Do you want to recess to do this, or? It's up to you.
Judge, this should be quick, because we
Okay.
agree to substance with everything else except for
That's
one
fine.
portion.
Go ahead and do it then.
I just want to leave the judge rule on this one. Okay. So you make your argument.
Your Honor, on page 9 of the
You know, actually, if you folks are comfortable with whatever you're doing, I don't think you really necessarily need
Well,
to.
Judge, there's just one, I completely agree with the redactions that Mr. Nardi is suggesting, with the exception of one, and we just wanted the court to rule upon that.
Could someone
Yes,
give me a transcript so I can look at it?
That would
Did
be
you say page
helpful.
9, Mr. Nardi?
Yes, Your Honor.
All right.
May I approach, Your Honor?
You may. And about we're on the page.
First question.
All right.
I think we're going to the evidence reading. The response, the evidence they can take out that I gave them, just this one.
Okay, yeah, that was what I communicated back with that. Keep it in my back pocket.
And because the detective is just relaying what somebody else said, that is hearsay as well as presents confrontation clause violation. And so I believe it would be inappropriate for that to come before the jury.
What you're referencing is the first sentence of the question?
Correct.
They're actually,
Well, it's that whole
Question
question. Yeah, to me, that whole question is based on something from what somebody else told him, Detective Liu being him. And so, to the extent he's regurgitating what somebody else had informed him, again, that's both hearsay as well as a confrontation clause violation.
all right. What's the government's position?
Judge, the confrontation clause and the hearsay rule applies in court. This is an interview room within the Maui Police Department made 2 years ago, where court wasn't even contemplated at this point. Police all the time use information to get more information, whether it's through hearsay, things they have personal knowledge of. It's a common tactic and it's a common question in all interviews. If they couldn't use, if you were to apply the rules of court to an interview with witnesses, persons of interest, or suspects, then you couldn't do an interview.
Well, let me just ask this question. To simplify this discussion hopefully. The information in the first question references a statement by another individual. If that were to be redacted, that would leave a second question that may, in the detective's mind, be based on that statement, but does not make reference to the statement. And
What rule says a police officer can't say, somebody told me this, is that true?
I'm just asking a question here.
Okay.
That's all I'm asking. The question that he really asked related to the condition of the dog, as opposed to what someone else said. That's the actual question. And the defendant answered that question. That's actually the second question, not the first question, which is really it includes the statement from another person. So in fact, the question that's asked and answered is the second question. And so the question I wanted to ask to you was, it would seem that the remedy there is to redact the first question, which was never actually presented. It's the second question that was presented to the defendant.
Well, the state doesn't have an issue with keeping the second question, and I quote, you know, so if the dog ran several miles and stuff over there, it should be tired or winded and stuff, but you know the dog is perfect. You know what I mean? The state,
And the
that's not
defendant goes
what,
on to agree.
right. No, counsel was requiring to delete the entire question as well as the answer.
Well, yeah, but when I look at this, the actual question that was asked is not based on something, it doesn't reference anyone else's statement, it's just really a statement of logic. If the animals run several miles, wouldn't it be tired?
Your Honor, you're correct, and I was just referencing the portion which was just reciting what somebody else said, which obviously doesn't apply to what you're speaking of.
So let me propose to the parties that you consider deleting the first question, which was never actually ultimately posed to the defendant, was the second question.
It's fine, so Judge has said there's no problem with that. So beginning on the question, beginning with the word you, ending with the word mean, question mark.
Right. Lines 1, 2, and 3. Ending with the word mean, question mark.
That's correct. The state has absolutely no problem with that.
Does that work?
Yes.
All right. Fine. Now, let me ask this. Are you able to redact that from what's going to be played?
Yes,
Okay. That's fine. Let's make sure that's done.
Yeah.
it's being done as.
You were doing some
speak.
hard copy redactions. I think you folks were working on that together. And I just want to make sure that whatever's played reflects.
Right, they're working on it right now.
All right. Okay. Why don't I return this copy to you? And then this is going to be done on the transcript that's provided to the jurors. Correct?
That's correct.
Let's go call him, make sure it's my answer my Yeah, that's what I was keeping.
Let me know when you're ready for the jury.
So I'm going to check on my witness if he's
That's
back.
fine. I'm more concerned about the redacted statements.
Oh, okay.
Both printed and recorded. I want to make sure that the redactions that need to be made have been made both on the recording as well as the transcript.
Thank you, Your Honor. Can we take a recess for a second?
To make sure that's done.
That's correct.
All right. We'll take a recess.